Good morning to all of you. It would be my pleasure to interact with the members of CII today on an issue which we think is important in the area of dispute resolution. All of you know that arbitration has earned a bad name in India, and we who got together to start the Nani Palkhiwala Arbitration Center went into the reasons as to why this is so. Why does a system which has so much potential to have disputes resolved in a quick, much faster and a much affordable way, why did it lose its utility, especially to the business community? This was the thought that got us to look at what alternates we have to the court system. As you know, today the court system is heavily overburdened. It has an inadequate number of judges to dispose of matters. At any given point of time, there is a vacancy of between 25 to 40% of the sanction strength. Or sanction strength of judges itself is not very good. Therefore, you are left with a sorry situation where a litigation in a court of law takes nothing less than anywhere between 15 to 25 years to get resolved. And this is not good for industry. It is not good for any class of people, more so industry, which needs to quickly adjust its responses to a dispute and try and ensure that the dispute is resolved at the quickest possible time. This is the thought that got us to start a Nani Palkhiwala Arbitration Center, which is a center devoted to popularizing what is known as institutional arbitration. There are two types of arbitration: ad hoc arbitration and institutional arbitration. We at NPAC strongly believe that it is because of the ad hoc arbitration earned a bad name in the country and has not been so extensively used as it should have been. And therefore, we are hoping that there will be a paradigm shift to institutional arbitration. And I am here today to tell you the advantages of institutional arbitration and to point to Nani Palkhiwala Arbitration Center, which is actually trying to apply these good principles to dispute resolution process so that we complete resolution disputes within a reasonable period of time, at a reasonable cost, and with least expense strain on the parties. So this is our aim, and this can take off only if it is supported by society, supported by people who tend to go to court, supported by people who are dragged to court. The other thing that I would like to tell you is that while there are several facets of the company, there are several facets of industry which invite a lot of planning, which invite a meticulous preparation, which invite a strategy. Unfortunately, as far as dispute resolution in India is concerned, very little attention is given by industry to this process. They all think of it as something which they will address when it actually arises. So we try to tell you that don't do that. Even when you sign a small contract with the vendor, kindly ensure that you have clauses which will come to your help when a dispute arises. Because as an advocate also, I have frequently come across situations where when parties come to us to sign an agreement and we suggest to them to look at a good dispute resolution process, they say that this whole thing will work only on trust and therefore let us not talk about dispute at this point of time. But unfortunately, hardly about 6 to 7 months down the line, they are knocking at our doors because there is a dispute and they want at that point of time a quick resolution of the dispute, which at that point of time is a little difficult to achieve. Therefore, our simple request to all of you is please pay a little heed and attention to this matter of dispute resolution, even at the time that you start signing contracts, be it with the smallest vendor or the largest infrastructure project. It is better to protect yourself by contemplating and planning for a dispute even at the time that you sign the contract, and choose the institutional dispute resolution process, because I am sure at the end of the day you will find that it is going to benefit you largely. I'll quickly take you through this PowerPoint presentation, and at the end of the session, please feel free to ask me whatever doubts you have. I start with my presentation with this famous quote of Mahatma: "Law is not an intellectual legerdemain. It is not magic. It is not trickery. To make black appear white and white appear black, but is a ceaseless endeavor to enthrone justice." This till the 70s in the United States faced a problem which is very similar to what we have. There was a huge backlog of cases, and the judiciary was battling to see that these were all contained within some manageable numbers. It was at that time that Warren V. Burger, the former Chief Justice of the Supreme Court of America, brought in this reform in dispute resolution, where he said that more and more cases will have to go for mediation, conciliation, and arbitration before they actually land up in courts of law. And this is what he told the American Bar Association. The entire legal profession has become so mesmerized with the stimulation of the courtroom that we tend to forget that we ought to be healers of conflicts. For many claims, trials by adversarial contest must in time go the way of ancient trial by battle and blood. Our system is too costly and too painful. As healers of human conflicts, the obligation of the legal profession is to provide mechanisms that can produce an acceptable result in the shortest possible time, with the shortest possible expense, and the minimum of stress on the participant. That is what justice is all about. The Law Commission, in its 127th report on resource allocation for infrastructural services in judicial administration, has stated that it is imperative to point out that the state today spends precious little, or to say the least, practically nothing on the administration of justice. In terms of a percentage of our GDP, it is 0.0078%, which is hardly anything. And that is what the government spends on the justice delivery system. I'm only saying this because these are the reasons which impel you to look at alternatives. Now, this is a very responsible study done by the Rajiv Gandhi Foundation. It's made an astounding assessment. Professor Vivek Roy says that we have today nearly 30 million, which is 3 crore cases pending adjudication all over the country. And on average, it takes over 20 years for Indian courts to adjudicate on a matter. And if land is involved, the time taken is longer. At the present rate of disposal, even if there are no new cases filed, he says it will take you 324 years for the system to clear the present backlog. And this is not some irresponsible statement. Rajiv Gandhi Foundation is a very, very respected institution, and Professor Vivek Roy himself is a very well-known name in the area of economics. And so what he says definitely bears some consideration. At this juncture, I wish to recall the words of Mr. Palkiwala, who said, "The law may not be an ass, but it is certainly a snail." And then he goes on to say, "The progress of a civil suit in our courts of law is the closest thing to eternity that we can experience." Now, why is the traditional and conventional court system not effective? There is a huge mismatch between the number of judges required for a country with a population of more than 100 crores and what is currently available. The public spending on judiciary is pathetically low, with the remote chances of this inadequacy being rectified in the near future. If therefore the constitutional promise of effective and speedy justice is to be a reality, courts will have to place heavy reliance on alternate dispute resolution systems. A well-regulated arbitration process that is quick, effective, and affordable can well be the answer to judicial backlogs and would be a source of great relief to harassed litigants. Now, it is effective to have effective and stable alternate dispute resolutions to strengthen our conventional court system. It is bearing this in mind that our lawmakers have enacted the Arbitration and Conciliation Act 1996. The provisions of this act itself encourages the establishment of institutions to aid and support arbitration and conciliation. Till now, institutional arbitration has existed on weak and unstable structures. I must tell you that it is worthwhile for us to follow countries like Singapore, because if you look at the type of support that the Singapore government has been giving institutional arbitration, it is really amazing. They've gone to the extent of stipulating that all the money which an arbitrator, mediator or a conciliator makes out of that process is completely tax-free. That government has also stipulated that all the money which a lawyer makes through arbitration, mediation and conciliation is completely tax-free. This makes sense because to support one judge in the High Court, you need to have at least 10 people attending to him. You need to have a salary, pay his salary. You take up costly real estate by providing housing for judges, and then there is a whole paraphernalia that is attendant of the functions of a judge. Now, if the state were to write off in terms of taxes whatever money it can get through this process, it is going to relieve itself of a huge amount of expense in terms of maintaining the judiciary. Therefore, the emphasis in countries like Singapore has been to encourage institutional arbitration. Unfortunately, that's not something that has caught on in India. The Arbitration Act Section 6 says in order to facilitate the conduct of the arbitral proceedings, the parties on the arbitral tribunal, with the consent of the parties, may arrange for administrative assistance by a suitable institution or person. Section 1110 says that the Chief Justice may make such scheme as he may deem appropriate for dealing with matters entrusted under subsection 4 or subsection 5 or subsection 6 to him, which is all relating to recognition of arbitral institutions. For example, the Nani Palkiwala Arbitration Center has been recognized by the High Court under section 11.6 of the Arbitration and Conciliation Act 1996, with an order dated 21/9/2005 passed by the then Honorable Chief Justice of the Madras High Court, Mr. Markandeya Kachu. Now, I was referring to the bad name that arbitration has earned in the past. A typical manifestation of that ill repute is this judgment of the Supreme Court, where the Supreme Court says, the Supreme Court, while referring to the 1940 Act, observed that the way in which the proceedings under the Act are conducted and without an exception challenged in court has made lawyers laugh and legal philosophers weep in view of the unending prolixity at every stage providing a legal trap to the unwary. It is therefore clear that unless institutional arbitration is encouraged and well established, the arbitration process will become a part of the many problems of the harassed litigants and not the solution. Now, this is a very common problem with our judicial system. A citizen comes to the court with X number of problems. So when he comes to the court seeking a solution, how should the system respond? The system should respond by reducing the number of problems. But what actually happens in practice is that the system itself becomes an additional problem. Therefore, you have X problems when you come to court, and the judicial process becomes X plus 1. And therefore, you are left with a greater problem than what you had when you came to court. So this is not a sound way to manage the system. Once again, Mr. Palkiwala, while drawing up the difference between arbitration and the conventional court system, said to sum up, a court of law is a Rolls-Royce of 1907 vintage. It is very stately and solemn, while the arbitration process is a 1987 Honda car, which will take you to the same destination with far greater speed, higher efficiency and dramatically less fuel consumption. In that speech, he pointed out 4 advantages of arbitration: speed, finality, affordability and justice. Commenting on the aspect of justice, he said that in the heated atmosphere of a court of law, the cold truth is sometimes obscured. The court of arbitration may be described as the place where the law approximates closest to justice. My invariable experience has been that parties with justice on their side are keen to go on with arbitration, while parties whose case is marked, shall I say, by an economy of merit are reluctant to embark on arbitration and would prefer the interminable delays arising in courts of law. In 2005, India attracted over 10 billion in foreign institutional investment and 8 billion in foreign direct investment. That figure has grown tremendously by now. In 2006, global and domestic private equity investors poured nearly 2.3 billion into 147 Indian companies. Currently, over 20 real estate funds are expected to raise estimates over $5 billion. Again, these figures are a little outdated. Earlier in 2006, analysts predicted that Bombay Stock Exchange would reach 11,000 by the end of the year, a figure that was reached within 3 months, and the Sensex appeared to be on steroids. One way to ensure that all this is short-lived is to allow our dispute resolution system to remain as they are. Conflict in areas of business is natural. Nobody can avoid it. And the very nature of business, it is possible that there would be disputes would arise. It may be good to avoid it, but experience has shown that it is inevitable. If we do not institutionalize, encourage, and adopt good dispute resolution methods, then sooner or later, investors are likely to become disenchanted with India as a much more sought after investment destination. Of course, attracting foreign investment alone is not the reason why we should give ourselves a good dispute resolution system. A just society rests its foundation on a legal system where laws are enacted after intelligent deliberations and are enforced in a quick and inexpensive manner by an efficient dispute resolution system. Commercial and business enterprises will find it impossible to survive in a climate where legal rights merely exist on paper and do not translate to realities. Therefore, we need to look at the types of arbitration that types of matters that go into arbitration, and also the types of arbitration that are in existence today. These once again are very, very broad classifications, and within these classifications you will have several sub-classifications. Now, one broad classification again is domestic arbitration versus international arbitration. What is a domestic arbitration? Domestic arbitration takes place between parties within the same jurisdiction, while an international arbitration in some way transcends national boundaries. In providing an agreement for the resolution of domestic disputes, a party may, in theory, choose between arbitration or litigation between the national courts. In deciding whether a dispute is international, two criteria may be employed. First is the nature of the dispute. Thus, an arbitration is international if it involves issue of international trade. Alternatively, the nationality or place of residence of the parties. Once again, let's look at the other broad classification, institutional versus ad hoc. The parties to an ad hoc arbitration, what is an ad hoc arbitration? An ad hoc arbitration is an arbitration where the agreement merely says that if there are to be disputes between the parties, it will be referred to arbitration. Under the provisions, usually most clauses will stop with just saying that. Some may go on to say that arbitration under the provisions of the Arbitration Conciliation Act 1996 or earlier the Arbitration Act 1940. So the problem with a clause like that is, once you have a clause like that, then it leaves several questions open. First question is, who will be the arbitrator? The second question is, what will be the rules by which the arbitration will be conducted? 3 is, how much do I pay the arbitrator? 4 is, on what scale are the arbitration fees to be determined? These several questions are left unattended in an ad hoc arbitration process. So therefore, what do? There is a dispute that arises. One party sends a notice to the other party refuses to comply with the demand, and therefore there is a dispute in existence. And you need to have this dispute resolved. How will you resolve this dispute? You have an arbitration clause, therefore you write to the party and tell him that I am appointing so and so an arbitrator. If the disputes are of such absolutely irreconcilable nature, then there is very little chance that the other party is going to agree to anything you say. Therefore, what happens? Then you move a court under section 11 of the Arbitration Conciliation Act for appointment of an arbitrator. Now, this application is taken up by the Chief Justice, and that application itself is pending in court for nearly 1.5 years. At the end of the period, the arbitrator is appointed. After the arbitrator is appointed, no care is taken to set out a process by which this arbitration will be conducted. You are also not very clear about the fees that an arbitrator is going to be charged. One of the issues which even the Supreme Court has commented is, if the arbitrator's fees are high and one party says yes and the other party knows that the arbitration fees are high, he finds it very difficult to say no to that, because he feels that if he is going to say that this fee is high, then the arbitrator is going to hold it against him in the arbitration proceeding. So he keeps quiet but becomes an unwilling partner to this entire process. This is what the Supreme Court itself has suggested. In fact, the Supreme Court has gone on to the extent of saying that all arbitrators to whom the matters are referred to by the High Court must disclose to the High Court what their fee structure is, so that the parties, before they can consent to that fee structure, knows what fee they would have to pay the arbitrator, because it makes no sense at all. If your claim is going to be only 10 lakhs, you end up paying the arbitrator something like 4 to 5 lakhs of rupees. Therefore, in an ad hoc arbitration, these are the problems. I'm setting out some of them. The parties to an ad hoc arbitration establish their own rules of procedure, which they formulate to fit the requirements of their case. By choosing an institutional arbitration, the parties elect to conduct arbitration in accordance with the procedural rules of that particular institution concerned and to have the arbitration administered by that institution. Decision of courts under the Arbitration Act 1940 and the Foreign Awards Recognitions and Enforcement Act 1996 should be considered with caution, as the 1996 Act purports to bring in a new approach to arbitration. This is also what you should remember. For example, under the new Act, agreement in writing includes a term contained in exchange of letters or telegrams agreeing to submit their differences to arbitration. Let's take a case where both of you have signed an agreement. There is no arbitration clause in that agreement, and then there is a dispute that arises. When the dispute arises, both parties understand that it is better to resolve that matter through arbitration. Even at that point of time, by sheer exchange of letters, you can agree to have the process determined through the process of arbitration. The only requirement is that that agreement must be in writing. In view of the specific provisions now, what about interference by courts in the process of arbitration? This is the note of caution which the Supreme Court has struck. In view of the specific provisions specifying the jurisdiction of the court to decide the matter, this court cannot assume, that is, this court means the Supreme Court cannot assume the jurisdiction. Whenever there is a specific clause conferring jurisdiction on a particular court to decide the matter, it automatically owes the jurisdiction of the other court. In this agreement, the jurisdiction has been conferred. In that particular case, the Supreme Court says that in this particular case, the jurisdiction has been conferred on the Chamber of Commerce and Trade of the Russian Federation as the authority before whom the dispute shall be resolved. In view of the specific arbitration clause conferring power on the Chamber of Commerce and Trade of the Russian Federation, it alone will arbitrate the matter. And finding of that arbitral tribunal will be final and obligatory for both the parties. What we are saying is, what the Supreme Court is saying is, that once the arbitration clause has been stipulated in the agreement, then the courts will take a hands-off approach to this entire thing. Once the matter reaches the arbitral tribunal or the sole arbitrator, the High Court would not interfere with the orders passed by the arbitrator or the arbitral tribunal during the course of the arbitration proceedings, and the parties would approach the court only in terms of Section 34 of the Act. Some courts have proceeded on the basis that any order passed by an arbitral tribunal during arbitration would be capable of being challenged under Article 226 or 226-27 of the Constitution. There is no warrant for such an approach. Now all that is gone. Previously, for a brief while, courts were also entertaining writ petitions challenging the appointment of arbitrator, but that now is clearly the story of something that happened in the past, because courts do not accept such challenge by way of writ petitions. Now, Section 5 indicates the extent of judicial intervention of the Arbitration Conciliation Act. It says that notwithstanding anything contained in any other law for the time being in force, in matter covered by Part 1, no judicial authority shall intervene except where so provided in Part 1. The expression judicial authority is not defined, so it has to be understood as taking in the courts or any other judicial fora. It would certainly include the court as defined in Section 2C of the Act, and would also, in our opinion, include other courts, and may even include a special tribunal like the Consumer Forum. In order to set aside an award, once again, okay, your question would be, fine, now I go through the arbitration process, there is the intense deliberation, after that an award comes to be passed. Now, what is my guarantee that the award will not be interfered by the court? Now, once again, the court says, in order to set aside an award, there must be a wrong proposition of law laid down in the award as the basis of the award. In short, what the court says is that on frivolous matters, the award will not be set aside. The attempt of the court always would be to preserve the award and not to have that award set aside. The court can set aside an award if it is, what are the grounds on which it can be set aside? If it is contrary to the fundamental policy of Indian law, or the interests of India, or justice or morality, or is patently illegal, or is so unfair and unreasonable that it shocks the conscience of the court. However, illegality of a trivial nature can be ignored. In addition to the narrower meaning given to the term public policy in Renu Sagar case, it has to be held. This is the judgment of the Supreme Court. I have just extracted that part, which is important. The award would be set aside if it is patently illegal. The result would be that an award would be set aside if it is contrary to the fundamental policy of Indian law, the interest of India, or justice or morality, or in addition if it is patently illegal. Now, the illegality must go to the root of the matter, and if the illegality is of a trivial nature, it cannot be held that the award is against the public policy. Award could also be set aside if it is so unfair and unreasonable that it shocks the conscience of the court. Such an award is opposed to public policy and is required to be adjudged void. Now, this judgment in ONGC has invited a lot of criticism to say that effectively the court which has been called on to set aside the award has actually become an appellate court. Now, while in theory that may be a valid objection to the judgment in ONGC, statistics have shown that the situation has not become so bad, and actually the number of cases where the courts have interfered using ONGC judgments are very, very minimal. And by and large, the courts still try to preserve the award and rarely try to interfere. And even if they try to interfere, it will be on certain particular aspects. Let's assume that the award has given covers about 6 to 7 aspects. Courts usually tend to, even if they want to interfere, will interfere with one aspect of the award or the other aspect of the award, and rarely do they set aside the award entirely. Again, after the award is passed, what is the power of the enforcing court? The power of enforcing executing court under section 36 to go behind the award. For the purpose of section 36, the court cannot be allowed to go behind the awarded amount and deal with the processes by which the amount was arrived at. So, you have this facility under the new act, which did not exist under the 1940 Act. In the 1940 Act, once an award is passed, it had to be made a rule of court. That has been dispensed with under the 1996 Act. Under the 1996 Act, all that it requires is the award has to be on stamp paper, and once it is on stamp paper, you can straight away take the award and execute it in the court of law. The Parliamentary Standing Committee on its Personnel, Public Grievance, Law and Justice, in its 9th report on arbitration and conciliation presented to the Rajya Sabha and laid on the table of the Lok Sabha on 4/8/2005, highlights that there is an absence of accountability of arbitrators. Let me come to certain difficulties. One of it has been pointed out by the Parliamentary Standing Committee. It says that there is a problem of accountability of arbitrators. Huge pendency of cases, no rules as to who can be appointed as arbitrators or regarding their fees, time limit for making an award and consequences of not making an award within a time limit. Now, all these are aspects which we addressed when we set up the Nani Palkhiwala Arbitration Center. Now, under the provisions of the Nani Palkhiwala, under the provisions of the rules that govern arbitration, in the first place, great care is taken while empaneling arbitrators. We don't want to have a huge bunch of about 1,000 arbitrators whose integrity and competency we cannot hold safe for. Therefore, a lot of attention is taken to empaneling arbitrators, and after the arbitrators are empaneled, we have a very good set of workable rules which will help the dispute to be resolved as quickly as possible. And fees are already stipulated. For example, somebody wants to decide to nominate Nani Palkhiwala Arbitration Center as the center for dispute of resolution. All that he needs to do is to look at the rules to see what would be the expenses that he can run up against. So, all this process is entirely predictable. The predictability of the process is its greatest advantage and its greatest asset. One of the things that the Standing Committee has recommended is to set up an Indian Arbitration Commission presided over by the Chief Justice of India along the lines of the Institute of Chartered Accountants of India, Bar Council of India, company secretaries, example, etc. So, there is a code of conduct to regulate the arbitrators, and suppose an arbitrator is guilty of violation of the code of conduct, there must be an authority before whom a complaint can be lodged and the complaint can be heard and decided. Therefore, with bearing that in mind, a recommendation has been made for setting up an Institute of Arbitrators that is yet to fructify, but that is one of the suggestions in the pipeline. The Arbitration Commission, once it is set up, would have the powers to grant accreditation to professional institutions which come forward to render services in the field of institutional arbitration. Such institutions would in turn frame its rules governing appointments, fees, conduct of arbitrators, delays, etc. Enrollment of arbitrators as members of such institutions would be made mandatory. Possible consequences suggested by the Standing Committee for Arbitrators guilty of not disposing of the case within the time limit where withdrawal of cases or blacklisting. So these would be the power of the Arbitration Commission. Now, let us look at the advantages of institutional arbitration. For example, availability of pre-established rules and procedures which assure that arbitration will get off the ground and proceed to conclusion with dispatch. Administrative assistance from institutions providing a secretariat or court of arbitration. A list of qualified arbitrators. Appointment of arbitrators by the institutions. Facilities and support service for an arbitration. Assistance in encouraging reluctant parties to proceed with arbitration. And an established format with a proven record. Now, at this point of time, let me take two examples. One is a case where you have only an ad hoc arbitration clause, and the other is where you have an institutional arbitration clause. When you have, as I told you earlier, when you have an ad hoc arbitration clause and when a dispute arises, you are forced to approach a court of law for appointment of an arbitrator. It takes a lot of time. Ultimately, the person who is going to be appointed by the court is not a person of your choice, and nor is it by an institution of your choice. And thirdly, you are left to the stipulation of fees by the arbitrator. There is no predictability to the process. You don't know how long the process is going to take. You don't know how long it is going to get for you to get an award in your hand. So nothing is predictable about the process. Let's take another case where all that you had taken the precaution of doing was to insert one paragraph in whatever agreement you sign, saying that if there are to be disputes, it will be resolved by institutional arbitration. Then a dispute arises. A and B enter into a contract and there is a dispute. And A sends a note of demand to B. B either keeps quiet or refutes that demand. Very simply, all that A then has to do, he has to write a letter to the institution and say that there have now been disputes between us and please now take over and ensure that the dispute is resolved around, in respect of in consonance with your rules. Then the institution takes on from there and it sends out notice to both parties. For example, under NPAC rules, we say that as soon as we get a notice, we send off a notice to both parties. Both parties will come to our office. We will give them a list of arbitrators. We will encourage both of them to identify an arbitrator by mutual agreement. Because once both parties come to the office of Rani Palkival Arbitration Center, then it helps us to understand the nature of dispute. What does this dispute relate to? Does it relate to accountancy? Does it relate to infrastructure project? Does it relate to trademarks? Is it a property dispute? Is it a money claim? So once we know what is the nature, then we can recommend, look, ABCD people are good people in accounts. The other set of people are good people as far as engineering contracts are concerned. So then we help both parties to arrive at a name and to identify an arbitrator to conduct the arbitration. Therefore, at that point of time, the arbitrator is not thrust on them. Both parties have an option. Of course, if both of them don't agree, then the institution will go ahead and appoint the arbitrator. But the process is at every stage designed in such a way that takes into consideration the aspirations and the expectations of the contending parties. Services that institution providing institutional arbitration society will provide are: determine whether there is a prima facie agreement to arbitrate, decide on the number of arbitrators, appoint arbitrators, decide challenges against arbitrators, ensure that arbitrators are conducting the arbitration in accordance with the rules and replace them if necessary, determine the place of arbitration, fix and extend time limits, determine the fees and expenses of arbitrators, and scrutinize arbitral awards. Now, I am giving you a broad range of arbitration functions by institutional arbitrations all over the world. In the Indian context, some of them may be possible by institutions in India, some of them may not be possible, but this is just a basic range of the type of functions which an institutions providing institutional arbitration will provide. Arbitration is popular not only I should say it is popular even in countries which have a good court system, because a conventional litigation in US does not take very long. But the National Arbitration Forum Washington in 2005 conducted a survey on the use and effectiveness of arbitration as a mechanism of alternate dispute resolution. The study revealed the following: 78% of the people surveyed find recovery faster through the arbitration process. 83% of the people find arbitration equally or more fair. 59.3% of the people find arbitration less expensive. 84.6% of the people find arbitration equally or more suitable for insurance sector. It is also revealed that while in a similar survey conducted in 1999, 59% of Americans choose arbitrations over a lawsuit for monetary damages. In 2003, this had increased to 64%. This is even in a country like US, where the court system functions very well, people prefer to go to arbitration. The advantages being, arbitrators are not bound by precedent and have great leeway in such matters as active participation in the proceeding, accepting evidence, questioning witnesses, and deciding appropriate remedies. Arbitrators may visit sites outside the hearing room, call expert witnesses, seek out additional evidence, and perform many other actions not normally within the purview of a court. It is this great flexibility of action combined with costs usually far below those of traditional litigation which makes arbitration so attractive. Now, once again, arbitrators have wide latitude in crafting remedies in the arbitral decision, with the only real limitation being that they may not exceed the limits of their authority in their award. An example of exceeding arbitral authority might be awarding one party to a dispute the personal automobile of the other party when the dispute concerns the specific performance of a business-related contract. Therefore, unless you are so totally off the mark that you are not even dealing with the issue that was referred to you for arbitration, by and large, you will have a lot of latitude in crafting the remedies, and only when you totally go off the mark and start adjudicating on disputes which really are not the subject matter of what has been referred to you, will the courts interfere and say that you have exceeded your authority. To ensure effective arbitration and to increase the general credibility of the arbitral process, arbitrators sometimes sit as a panel, usually consisting of 3 arbitrators. Often the 3 consist of an expert in the legal area within which the dispute falls, such as contract law in the case of a dispute over the terms and conditions of a contract, an expert in the industry within which the dispute falls, such as construction industry in the case of a dispute between a homeowner and his general contractor, and an experienced arbitrator. While a court-managed litigation does not give the parties an option in choosing the judge, in an arbitration process, this is possible. Sometimes now in courts, a civil suit is heard by nothing less than 7 to 8 judges, because judges have portfolio allotment once in 2 months or once in 3 months. So a trial may start and it may well go on before several judges. Now, of course, in the High Court, the matters are now being referred to a master, but even the master may change for taking evidence. Therefore, this process is really not a very happy process. While the above are the different advantages of arbitration process, it should be considered that institutional arbitration process has not become as popular or as frequently used as it should be. Now, you can well ask me, according to you, this is all apple pie, this is all a wonderful system. So why has it not become so popular? I must admit that there are certain disadvantages in the process. Let me tell you about some of the disadvantages. One, we do not have very many institutional arbitration centers. Mainly the problem is very, very low awareness about the advantages of institutional arbitration. That's why this is very good that institutions like CII must organize more of these type of conferences, which will increase people's understanding, and it will be easier to get people, familiarize people with the process and create greater awareness and sensitivity to this process. So the first problem is we do not have very many institutional arbitration centers maintaining internationally acceptable standards similar to those maintained by International Chamber of Commerce or the American Arbitration Association. Further, awareness about the usefulness of the institutional arbitration process or awareness about the presence of even the existing centers is quite low. institutions like Nani Palkiwala Arbitration Center has been established to fulfill this long-felt need. By its very nature, such centers can't be run on a profit motive. These have to be run as public utility centers. For example, the Nani Palkiwala Arbitration Center is a completely non-profit organization. There is no declaration of dividend. There is no distribution of profit. Every pie which the institution makes is plowed back into creating meaningful facilities for the process of arbitration itself, and it is addressed both at the academic, as an academic institution, and also as an institution that supplies these facilities. For institution to be successful, interference by court should be minimal. This is something which is not in the hands of arbitral tribunals, but slowly this is catching on. Because courts have been told that they should not interfere in the process, because if they start interfering in the process, then, because today the greatest fear for any foreign investor to agree to an institutional arbitration in India is that courts will interfere. He is very happy about every other thing. The facilities are very good, the quality of the people are very good, the para facilities are also very good, support facilities I mean are also very good, and therefore while all this is very happy, the institutional arbiter investor is afraid that we don't have a discipline. But that is changing. Courts now are not too happy to interfere. And over a period of time, when you establish institutions whose very name will lend credibility to an award, then that becomes so much more easier for the court to rest its confidence on such institutions. That's one of the purposes for establishing institutions like the Nani Palkiwala Arbitration Center, because then the very credibility of the institution adds to the worth of the award. Courts would also be restrained from interfering at every stage of the arbitral process once it is convinced that the process has been conducted through a process of institutional arbitration that is credible and acceptable. We need to reach this balance at some point. Further, today, Indian sentiment has abhorred the finality attached to arbitral awards. The attitude of at least one party to the arbitration is try to win if you can. If not, do your best to ensure that the other side does not realize the benefits of the award. The court must not lend a helping hand to that process. The Arbitration Act 1940 committed a grave error in allowing courts to interfere when the award suffered from patent legal errors. Interference on this ground then becomes subjective. It is to rectify this that the Arbitration Act 1996 now provides that the arbitration award would be set aside on the very limited grounds like lack of jurisdiction of arbitrator, fraud or corruption of the arbitrator, or of the rival party, etc. The good news is that the Supreme Court is increasingly frowning on attempts on the part of lower courts to needlessly interfere in arbitration proceedings. After the judgment of the Supreme Court in ONGC, the real position is courts have been given the power to interfere even there is a patent legal error. But in practice, courts are not so happy to interfere. That is a general trend. You may point out one or two cases here which are exceptions, but the general trend is to preserve the autonomy of the arbitral process and to ensure unless parties go wrong gravely, there is violation of principles of natural justice, somebody has not been heard. Just on this aspect of this calculation is wrong, it should not have been 2 into 2, it should have been 2 into 3. Things like that, courts don't interfere. They keep a hands-off attitude, and that is how the process is proceeded. The process of encouraging a settlement within the arbitration process has also not become popular. We need to make processes like this popular. In foreign countries, you have this process of MEDAR, clauses that provide for a process of mediation prior to the commencement of the arbitration proceeding should be encouraged and implemented through institutional ADRs. The Nani Palkiwala Arbitration Center, for example, provides in its rules that parties shall first attempt to resolve their disputes through mediation before resolving it through arbitration. This trend has to be encouraged. On an all-India basis, we still lack institutions that impart education and training in arbitration, mediation and conciliation exclusively. Moreover, the training students receive in law schools prepare them to be warriors of conflict rather than healers of conflict. On the other hand, in Western countries, lawyers devote more time to negotiating conflicts than they spend in the library or courtroom, and studies have shown that their efforts to negotiate are more productive for their clients. All this must be streamlined in such a way that as soon as a dispute happens, the first response we should be to try and resolve that dispute amicably. You must have an attempt at mediation. If mediation does not fail, then you go to the next step of taking the matter to arbitration. At all points of time, the parties must be discouraged to go to a court of law. The courts of law today cannot handle this large number of disputes, and therefore we need to streamline the process to ensure that much of the litigation, much of dispute resolution happens through participation of the parties, and a system is not imposed on them which forces them to resolve the dispute. The last but most important point is to address the lack of awareness about the benefits of alternate dispute resolution system generally and of institutional arbitrations in particular. As stated earlier, disputes arising in banking and finance. Look at the range of cases that can go into dispute resolution through arbitration. Disputes arising in banking and finance, business disputes, clinical and medical negligence, commercial agencies, construction and development, energy, intellectual property, insurance, maritime and shipping, commercial contracts, corporate finance, engineering and manufacturing disputes, partnership disputes, property and real estate, railway industry and transport, shareholders agreements, regulatory disputes can all find simple solution through the process of alternate dispute resolution and institutional arbitration. All that they need to do is provide a simple institutional arbitration clause at the time of entering into the contract. Even after the dispute arises, it is open to the parties to refer the dispute to institutional arbitration voluntarily, even if the earlier agreement had not provided for the same. However, neither the public sector nor the private sector appears to have capitalized on the benefits offered by the Arbitration Conciliation Act, and they continue to resort to costly, protracted and complex court litigation quite unnecessary. This is just a picture of Nani Palkhiwala Arbitration Center. We have facilities of a proper courts which can help you to, which can give you all the managerial support in the dispute resolution process, and these are very well furnished rooms, and as the evidence is recorded, it is available on the screen for both parties to see where the evidence is being wrongly recorded or whether it's being properly recorded. Corrections can be made. We provide very good infrastructural support facilities like copying and secretarial help to take down dictations. And with all that, I think the process of institutional arbitration must help industry to resolve disputes, as I said, within the shortest possible time, with the least expense, and in a manner which is satisfactory to both parties. Ultimately, when a party goes to court, it is not that you win or you lose, but you must be given a proper opportunity to put forth your point of view. You must have the satisfaction that the person who is listening to you has the intelligence to understand the issues that are being put to him. He has the capacity to deal with it by writing a reasoned award. All the aspects that you take into, because under the Arbitration Conciliation Act, unlike the 1940 Act, you can't have an unreasoned award. And therefore, you must be confident that the person to whom you are referring the matter has the capacity to answer all the queries that you raise. So that is the greatest advantage of institutional arbitration, and it is our earnest hope in the Nani Palkhiwala Arbitration Center that more and more people will jump into the bandwagon of institutional arbitration. As we said, very, very simple to get into this. All that you need to do is to go into our website, the Nani Palkhiwala Arbitration Center. If you Google, you straight away led to our website. In our website, we have a standard clause. All that you need to do when you sign an agreement is to cut and paste that clause. You don't even have to inform us. We are informed only at the time that the dispute happens. So the process of availing this facility is actually very, very cheap. Actually, there is no expense involved at all. All that, as I said, go into our website, identify the clause, do a cut and paste, put it in the agreement. And when the dispute arises, it's only at that time you need to approach us. Therefore, if you are going to sign 1,000 agreements and disputes arise only in respect of 3 or 4, your expenditure for the dispute resolution will be only in respect of these 3 or 4 agreements, and not in respect of the 1,000 agreements to which you have an institutional arbitration clause. Therefore, the process of even availing this facility is very, very cheap and effective, and we do hope that there will be a paradigm shift and people will start planning for dispute resolution even at the stage when